Changes around like an ocean in my head. I can almost feel you walking in the distance, but I know that it's not reality. If you are echoing around inside these parallel dimensions all alone, know I'll find you in my dreams. I can almost feel you walking in the distance, but I know that it's not reality.
Hey guys. Hey, did that freak you out with a whole new beginning? A whole new beginning? Hi. Happy. What is today? Thursday. Happy Thursday. I missed you guys yesterday. I'm sorry. I'm sorry. By the time kiddo got done with class, it was crazy. It was crazy. Crazy, crazy, crazy. It is Thursday. I know. I know. So did that intro throw you guys for a loop? Did it throw you for a loop where you like, wait, where am I? Where am I? And what have you done with Jenny? Mm. I hope you guys are doing well this week. Hey, Melanie, it's good to see you. Hope everyone is having a good day, week. I'll be lurking and working, but we'll give my 2 cents. I mean comment when I have a chance. There we go. I like that. Hello, Miss King. I hope you're feeling better, dear. I hope you are feeling better. Hey, sweet Brenda. Hello, hello. Hello, and how are you? Hey, Donnie. Hey, hey, hey. Hey, Miss Sherry. You like it? Good deal. Hey, Morgana Banana. Hey, Robert. Good to see you. Oh, you were supposed to be at work today, but got the day off because of the snow. Nice. That's nice, Robert. What did you do instead? Yes, I have my coffee, coffee, coffee. Yes, coffee, coffee, coffee. Mm-hmm. Melanie says I'll be singing once my work week is done. I bet. It's almost Friday. Almost Friday. Free again. Hold on, let me get my kiddo's math paper out of the way. I'm here to tell you my girl is a numbers girl. She does much better at math than she does at reading and words. So, she's really good at math. Oh, you have a nice hot cup of coffee from Timmy Hortons, huh? Lucky you. I have a nice hot cup of coffee from my kitchen. From my kitchen. It's good too. It's yummy. Hold on, I've got something on my glasses. I cannot stand that. Can't stand it. Oh, so you guys, I went to the doctor, right? She put me on, um, she doubled my blood pressure medication dosage. She doubled it, which I know that's normal. I mean, what I was taking is losartan, and I was taking 50 milligrams, and she increased it to 100. Did I already tell you guys that? I don't remember. Hey, Henny. Hello. No, Brenda, I was on lisinopril, but she took me off of that because I had a stupid cough with the lisinopril. So she switched me to losartan back several weeks ago when I was sick, like with the junk. And she started me out at 50 milligrams of losartan, but she doubled it to 100. But I think from what I've read, that's like a normal dosage. And then I have to go back tomorrow just to check in because so as far as telling a difference, Brenda, I can tell a difference definitely. Like as soon as your profile picture, ma'am, you smoking. And by that I mean hot. Look at you. Pretty thing. Do your thing. Do what you want to do. Hold on, I was just checking. Let me turn my notifications off. Yeah, look at you, Hot Brenda. Hot Brenda. By the way, you guys, let me just say really quickly, if you are looking for handmade jewelry or little like stones and gems, tchotchke, like pretty things, you might want to check Brenda out. Brenda and her daughter have an Etsy shop. And she sent me this pretty little bracelet. It's a pink, it's rose quartz beaded bracelet. And I'm pulling my inner Justin from Clutch Them Pearls and put it on my microphone just because it's super cute. But anyway, yeah, super cute stuff. She has really pretty stuff. And I don't know, Morgana, is there any way you can grab Brenda's link for me and put it in the chat? If you can't, let me know, and I'll I don't see any other mods in here at the moment. Thank you, Morgana. Thank you, ma'am. I appreciate it. Yeah, it's super cute, right? Super cute. Super, super cute. And, oh, here's another one of the little things that she made. What do they call these again, Brenda? A worry stone? It's a little green jade. I think jade. And you just rub it, Don't mind me. I'm missing a pointer and a thumbnail. But yeah, I love these. I keep it handy on my desk all the time. I love it. Love it very much. All right. So, you're welcome, Brenda. I love it. I love the stuff. So, let me say, I was taking the lisinopril, went to the losartan. Immediately, the cough went away. So, I know. I mean, I was sick on top of that, but I had that like little irritating, aggravating cough ever since I started the lisinopril. And yeah. So the losartan has been doing pretty good, but however, and I'll tell you this too, since I started taking it, the swelling in my like legs, the like edema, that is such an ugly word, um, went away, like, and stayed away until the last like week or so. And it's back. And I noticed my blood pressure was going up again. And I started getting headaches and not feeling good. And so she went ahead and bumped it up to 100 from 50. And if that doesn't work, then I'll probably have to start taking a second blood pressure pill. I know, right? Edema is right up there with moist. Yuck. I don't like it. Um, but anyway, yeah. So I have to go back tomorrow, and they'll check my blood pressure then. Yeah, Morgana, it is. Here, hold on. Let me know if you can find it. If you can't, I'll grab it. Um, but anyway, so I was scrolling around. We're going to have just a little bit of a healthy journey update for me before we get started on some explosive updates yesterday and today. Anyway, so yesterday I was just scrolling through YouTube, looking at this, that, and the other. And I love Mel Robbins. She's like a entrepreneurial, motivational guru. Okay, she's the one that's got like long, like blonde hair and big black glasses, and I love her so much. I've listened to her for over a decade, like years. Okay, and not like consistently, but just when the mood strikes. Everybody needs a little Mel Robbins in their life. So I saw this thing that popped up, and it was talking about she has a podcast where she talks about random stuff with different like experts that come in and hang out, and they have a little chit chat, and this dude was on there. Hey, Cherie, this dude was on there, and I was watching it, and I took some notes, and he was talking about like health stuff, right? And he's a vascular doctor, I think he said. Anyway, they were talking about, I think the title got me. It was like 5 things to eat right now to help you feel better or whatever. And so what do? I went straight and got all the stuff, right? And it's not supplemental stuff. It's stuff like tomatoes, pomegranate juice, kiwi. What else was there? Sourdough. He said sourdough bread. Matcha, but I'm not a big matcha person. Hold on. Let me go look real quick. Hold on. Hang on, Morgana. I'll grab it, honey. Oh, wait. Why is that not? Hold on. My computer is being wonky. Oh, hold on. Bum, 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 bum. Now, I just looked at that the other day. Why is it doing that? HTTPS. It's giving me this like privacy thing. Hold on. There, I got it now. Jeez Louise. Copy. I got it, Brenda. No, no worries, Morgana. I had a hard time finding it too. And I thought I had it bookmarked, but apparently I did not. There you go. See if that link works. See if that takes you to Brenda's Etsy shop. Let me know if it don't work. What was I saying? Okay, thanks. Thank you. Yeah, she's got some super cute stones and gems. Really pretty stuff. What was I saying? Oh, about the matcha. I'm not a big, I like tea, but I'm not a matcha fan. But anyway, I'm looking at what I wrote down. So, those are just some of the things that I bought. And he was talking about one of the really, healthy, which you wouldn't think would be healthy. And he said it's actually very healthy. And he kind of went into why, but he was talking about tinned seafood, which is like canned tuna or salmon or mackerel or sardines or, that kind of stuff. And he said the reason it's healthy is because it's fresh, like they catch it, they smoke it, like on the ships. I didn't know this. And then they package it in the cans with the seasonings and the oil and all that, like right then. And I just thought that was pretty cool. I didn't know that. But he said to get the kind in extra virgin olive oil. And he said, to get the kind with like the different seasonings. So I got some because I usually have to smear like mayonnaise all in mine. I usually buy it in water, and then stir a bunch of mayonnaise in it and slap it between two pieces of white bread, and I'm golden. But, um, so I've got my little healthy, this is my lunch. Haven't had a chance to eat it yet, so I'm going to eat it here in a minute when I start playing one of these videos. But look, it's the tuna. Hold on. Ooh. And it's basil and pesto with extra virgin olive oil. And I have my piece of sourdough bread and tomatoes. So that's my lunch. And coffee. Anyway. But something else he said that really interested me was do not, what did he say? Oh, bottled water. Plastic bottled water is a no-no. He said that there has been studies that have shown microparticles of plastic in our bodies. Like even in the plaque that is found in the arteries, they've found microplastic. And he said statistically, the American, how did he say that? It was something like the average American consumes about one credit card size amount of plastic per year. Yeah. If you like add it all up, all the little microparticles of plastic that we ingest through water, not only bottled water, but food that's packaged, in plastic. But anyway, yeah, it's all a thing, right? It's a whole thing. Just let us be. And he says to buy it in glass if you can. He said if you have to get it in plastic when you get it home, store it in glass because that's better than not. And he also said not to store food in plastic containers, like Rubbermaid container. Tupperware, I'm sure, is safe nowadays, right? I don't know. But he said glass or ceramic is better than anything. Yeah. I won't drink tap water either. Hey, Kel, I didn't see you pop in. She said, I add one sardine to my Nova's dinner every night for the healthy oils. Her skin isn't dry like it used to be, and she loves it. Oh, of course she loves it. And you know what? I have got some canned sardines. I should do that for Poppy because I've got some canned sardines that Miss T-Maw talked me into buying. That was a no-go. I'm like, no. Yeah, Cherie, don't put plastic in the microwave with food in it. Yeah. I know. Okay. Are you guys ready? Let's get off the health stuff. I will let you know what the doctor says tomorrow after I talk to her about my blood pressure stuff. Anyway. But I want to get into some of this business that's been happening today and yesterday. So before I get into the Karen Reed things, put a 1 in the chat if you guys saw the verdict for Collin Griffith yesterday. Collin Griffith is the young guy that was on trial for his mother's murder. Put a 1 in the chat if you watched it or heard what the verdict was. I'll give you guys a second while I put some chapstick on. Morgana and Miss King. Are you two the only ones? What, kiddo? What? What you got? Oh, do you need help with that? Hold on just a second. Okay, so Kel said she heard. Henny heard. Okay, so some of you guys know. Well, I'm going to talk about it. So if you haven't seen it yet and you don't want it to be spoiled, if you don't want, spoiler alerts, well then, I don't know, because we're going to talk about it here in a second. I'm just saying. Cherie, right? Oh my God. All right, so I'm going to give you guys that don't want it to be spoiled for you on the count of 3 to mute me for a few minutes. I'd say a few minutes because we're not going to spend too much time talking about it. But, yeah. All right. 3, 2, 1. Goodbye. Hi, Courtney. Hi, Courtney. All right. So, the Collin Griffith verdict yesterday, you guys, I don't remember if I was on YouTube or if I was on X. And I think it was on X because it was Kathy Russin that I saw the tweet from. And it said, Collin Griffith found not guilty. And my mouth just went, what? Are you serious? What do you guys think about that? Are you shocked or did you see it coming? Like, I was shocked. I was super duper shocked. Blown away shocked. I couldn't believe it. I figured that they would either find him guilty or it would be a hung jury. I never thought in a million years that they would say not guilty. But I can see... I can't, really give a definitive what my opinion is because I didn't watch it all, right? But I will say from what I saw, I was very much reminded of like how a lot of people felt about Ethan Crumbley with the, like screaming for help, hollering for help, yelling, like asking for help over and over and over, over and over and over and over and over and over and over. And I feel like he was failed, Now, if there's any one particular person or agency or whatever that failed him, I'm not sure because, like I said, I didn't watch the actual trial, the whole thing. But I watched enough to know that he... Hi, baby. I watched enough to know that he for sure had issues. You know what I'm saying? So I don't know. Henny said she was shocked. Cherie's shocked. I know, right, Cherie? That's what a lot of people were saying too. They were like, "Oh, goodness gracious," you know. I read a lot of people saying things like, "Oh, I want to hope the grandparents aren't next," you know. I don't know. I don't know. And then there was some mixed, like I'm not sure either. Do you guys know, like, definitively one way or the other, if the jury was allowed to know that he had shot his father? Because I was thinking that they knew, or they heard, it was, I thought it was mentioned in the opening statements but glossed over, and they didn't allow evidence that talked about it. But I could be wrong about that. I'm just wondering if those jurors come out and then hear about the dad situation a year prior, and they're like, "Oh my God, what did we do?" You know what I mean? I mean, I would if I didn't already know about it, but I'm not sure if the jury did know, but they just didn't know all the details. If they just heard that he shot him in self-defense, you know. I wanted to go back and re-listen to the opening statements. Miss King says no, all they knew was he had killed a person. Prior to his mom? Or is the mom the person we're talking about? I really want to go back and watch the whole thing from the beginning. Yeah. Oh man. Yes, said Miss King. Yes. Prior. Okay, so they knew that he had killed someone prior to the mom. Okay. Well, I mean, I hate to say this, but like in the grand scheme of things, okay, let's just say, hold on. I'm going to go over here and fix my little thing so kiddo can't come in and out of here as often. Um I'll be right back. Hold on just 1 second. Okay, I'm back. So, what I was saying is if you were on the jury and you heard, that this kid, 17-year-old kid, kills his mom, he's on trial for it, and you hear that he had previously killed someone, but charges were dropped because it was self-defense. Would it matter to you who it was? Would it matter if it was a complete stranger or you find out that it was his dad? Would it really matter? You know? I mean, I know it matters, but to the jury, are you going to look at him any different whether it's someone that you don't know versus your parent if it's in self-defense? Okay. Miss King says, I think it would. Kel said it would to me. Henny says, no, murder's murder. So I think it just, I don't know how I would feel. I don't know how I would feel. I would be like, okay, regardless of the situation, if they've said it was in self-defense, okay, and charges were dropped, he's killed a second person now. I mean, allegedly. He says he didn't, but she fell on the knife. I don't know. But I just don't know. I don't think that I would know how I would feel about that unless I was there and could see and hear everything all in like one total package, you know? Hey, Kayleen. She says, I admire Jenny taking the time to protect her children. She said, oh, thank you. Thank you. I appreciate that. Thank you. I try. Let me see. Brenda says it would to me, but it probably shouldn't because he had already been charged. Or in his case, not charged. Yeah. For the first one. Kel says, what are the odds that someone would unalive both of their parents in two different instances where both were in self-defense? I know, right? But I'm thinking in my head, I'm thinking if someone kills someone in self-defense, what's the chances that they're going to ever kill anybody ever again in their lifetime by the time they're 17 years old? You know what I'm saying? So in my mind, I'm thinking I think the parent, I would look at them more oddly, like side-eye them, had I known it was the dad, but knowing in general that he had killed someone prior and then killed a second person in self-defense, I'd be like, really though? I mean, what are the chances of that? Hey, Kelly, good to see you. Hey, y'all finally made it back to alive. I had jury duty. How'd that go? Can you talk about it? Cherie says, somehow I don't believe that he killed his dad in self-defense because what he said to his grandparents. Yeah. Kel says, true, if it was legitimately self-defense the first time. Right. And that's what I'm saying. Like, one time I can understand and charges were dropped. 2 times though, and by the time he's 17, I can understand one self-defense situation by the time you're 17. But if there's going to be another one in your lifetime, it should be like when you're 70 or something. There should be a limit as to how many self-defense. I don't know. I'm being goofy there. I'm not being legit, but I'm just saying that's very strange. Kelly said jury duty was boring AF. Never got picked, but did voir dire about 4 times. 4 times? Jeez, why 4 times? Did you have to go through like stages? Did you say, yo, I love true crime and I watch a really cool channel on YouTube called Crime Cafe? Tell me you said it. Tell me you did. Even if you didn't, tell me you did. Oh, gosh. But yeah, I was blown away by that verdict. I kept looking at my screen like, am I being, and I think I even asked the girls, I was like, am I being punked? Like, I just did not. Different cases, they didn't like my true crime answers. Mm, cute. Cute, cute, cute. I told my husband because he got like a jury duty form, to fill out and send back in. And he, I can't remember when that was. It's been a month or two ago. But I told him, I said, well, if you get called and they like start questioning you, just tell them, hey, my wife has a true crime channel on YouTube. I and they'll be like, okay, next, get him out of here. Hmm. She said, I named all y'all: Crime Cafe, Lawyer, Emily D. Baker, Tanika. I called you all out. Yay. Nice. Good deal. Good answer, ma'am. Good answer. Hmm. Great answer. I don't know. As far as the Collin kid goes, I'm kind of wondering, like, where's he gonna go now? Where's he gonna go now? Like, he has no job. Well, I'm sure he doesn't have a job now. I don't know how easy it would be for him to get a job right away. And then the living situation. I'm assuming he's going to be living with his grandparents, right? Um, and I just kind of wonder what he's going to do. I'm sure for the next good long while he's going to be laying low, because I'm pretty sure locally he's going to have people that's going to be like, you know how that kind of stuff goes. Kel said they didn't like that you're knowledgeable about trials and are an independent thinker, Kelly. There you go. There you go. And they'll be next, said Henny. Oh, that's what I worry about. Eesh. Sherry said he wouldn't be living with me. Morgana said I'd be a little worried if I was the grandpa because he testified against him. Are the grandma and grandpa together or no? Like married and cohabitating? I don't know. See, I didn't really pay much attention. I don't know though, because Morgana, the grandpa, when he testified, he was very, like, didn't like give him up to the like, he just kind of let it go by the wayside and didn't really say anything to anybody when he mentioned what he wanted to do to his mother. I don't know. I don't know. I don't know. Kelly said, I feel so behind. There are 2 jury watches. The crazy Ponzi lady got sentenced. I missed so much. Yeah, the Ponzi lady did get sentenced. Yeah. She did. You really should watch that one, Kelly, because we streamed it. What? It's been a few days ago now. Mercy. It was called Mercy Phase or Mercy something. Morgana said he did talk about what he'd said about his mom, though. Yeah, he did do that. He did. I don't know, y'all. I don't know. But now we're going to switch gears because this is what I've been wanting to talk about. I really wanted to talk to you guys last night about this Collin Griffith thing. But by the time I was able to do a live stream, it was like 7:30 or 8 o'clock last night. And I was like, I don't know. But today, for those of you that have been following the Karen Reed situation, today was a little bit crazy pants. Kelly said, I watched the first few days of the trial with y'all and her lawyer, Balky's uncle. His uncle. Uncle. His uncle. I'm going to, let me go find it real quick. Oh, and you guys let me know too if any of y'all have been watching the Megan Boswell trial. I've been trying to stay caught up with it, but I've not. I'm failing miserably. Failing miserably. Oops, did not mean to do that. Hold on a minute. Well, where did it? Oh, here it is. Nope, that's not it. Where did I get rid of it? Daggone it. Oh, here it is. Yeah, let me know if you're watching the Tennessee v. Megan Boswell trial. They are on what day 2 today. Henny said, I haven't watched anything. The Megan Boswell is sad. And I'm going to be honest with you guys. When we mentioned it the other day, I said something about not wanting to stream it because little kid. Because y'all are like, oh, the kid ones are killing us, blah, 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 blah. And I get it. But then the name sounded familiar. But I had been so busy, I hadn't really looked. And when I was scrolling, I saw who they were talking about, the little girl and her mom. And I was like, that's who Megan Boswell is. I didn't put the face with the name. And I did want to watch that. Because I remember seeing her like on the news talking about her daughter and how she was missing and all that. So Morgana says I started but I'm not caught up yet. And Brenda said the little girl, I've been trying to watch it. Yeah. Yep. All right, let me share. Hold on, the screen. Where did it go? Here it is. All right. Now, Kel said, I started watching it, but the details are horrible. Here's the thing, Kel. Like, it's always. I'm always interested in the ones. I mean, there are some that I'm interested in, like for instance, Madeline Soto, right? Stefan Cerns, all that whole mess, just because of the situation, right? Like, I'm heavily invested in that case. For no particular reason other than it just the situation, it's very different, very difficult. But like in the case of Kaylee Anthony, I was hardcore invested in that trial, but at the time when she was missing and they were looking for her, sorry, I thought I heard somebody. I think it's Kiddo walking down the hallway. Did you see the music teacher at Maddie's school was arrested? No. What for? Oh my God, what for, Miss King? Kelly said the ones with kids are too much for me too. I know Maddie Soto's trial starts this month and I'm trying to work my way up to it. Yeah, I'm going to watch it. It's going to be difficult, but yeah. Yeah, I know, right? What, Brenda? What a picture of little boys. Oh my God. Lord have mercy. But it had nothing to do with Maddie, correct? What was I saying? Oh, whenever the story broke about Kaylee Anthony, at that time, my son was about her age. And so it hit me different, right? With Harmony Montgomery, it hit me different because my little girl. And so there are just some that, like, you would think that I wouldn't want to watch those because my kids were that age or whatever when that occurred. But it's like it has the complete opposite effect. Like, I want to because I'm invested. And yeah, it's weird. Right, Brenda? Weirdos. People are weird, man. Kelly said, I can do it if I'm on a live with people I like. Plus, Dave Cacciatore is prosecuting it. Well, you can come hang out with us. We're really good about, like, on the difficult cases. The moderators are really good about reminding everybody to take a step back when they need to. And we're always there when they're... And there's been times when I've had to take a step back. There's been trials that we've watched, and right in the middle of the live stream, I'm like, I got to go walk away from my computer for a minute, you guys. Like, and not just to go get the kids something to eat. I mean, to take like a mental break for 2 seconds. But yeah. Miss King says nothing to do with Maddie, but he was one of the teachers on the police interviews that have been released. Whoa. Wow. It's like you need educated on the child ones. Well, I mean, partially, but it's almost, I don't know how to explain it. I don't know how to explain it. You would think when you have kids that are the same age as one of these child victims that we hear about, that is nightmare fuel for you, you know? But also, I know that she was in his class. Whoa. God. Oof. Awful. Also, I think I got invested in those because I fully believe and believed then that Casey did something to Kaylee. And I wanted to see her get what was coming to her, although that day never happened. Justice was never served for Kaylee Anthony, in my opinion. But she'll get it one day. She'll get it one day. She'll get it. And then same with like Adam Montgomery, with Hannah, with Harmony Montgomery. You know, it's like I want to see justice for those babies. It's just awful and awful and awful. All right, on this Karen Reed hearing, you guys, listen to this. All right. I know a few of you have already watched this hearing today. Do y'all know? I'm going to let you all say it in the chat if you want to, because I know that you're going to say what I'm thinking. But if you've already watched this Karen Reed hearing, tell me in the chat why my mind is blown about what they said in today's hearing. Cherie, I know, right, honey? There's one case I don't think we'll ever know who unalived Summer Wells. I know. That one breaks my heart too. And do you know she just had a birthday? I was not aware of that till just a couple days ago, I think, was her birthday. And in 20 more days, today is February the 6th, in 20 more days, Sebastian Rogers will have been missing for 1 year. 1 year. I pray to God he's found before then. To be honest, I pray that he's found long before then. Let me see. There we go, Morgana. Higgins lied. Well, it's not so much. I mean, I'm not really mind blown that Higgins lied because, but I'm blown away that how we found out that he lied. That's what blows me away. Miss King says, I've not seen it, but I can't believe they're going forward with this case. I know. We're going to start this hearing, okay? It's not long. It says an hour and 25 minutes, but a lot of it we can skip past. They have one sidebar that lasts like 20 minutes or something. But so it's going to be short, but there's some really good nuggets in this hearing today. I was like, wait, did I just hear what I think I heard? I had to rewind it like 3 times to understand it. But we're going to start this, okay? I'm going to actually start it and eat my lunch here because I'm starving. So I'm going to eat my lunch real quick, turn my camera off and mute myself and let you guys see this. Oh my goodness gracious. Mercy me. Hold on, let me. Ha cha 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 cha. Okay, here we go. Fast forward it because apparently Judge Bev is. So I will say they must have started this stream before we had a. Hold on. I have to move this tab out of my way. I can't see what I'm doing. They must have had the stream going for a few minutes before they turned the feed on because Bev is reading something to do with what they're talking about. And you can see, not Yannetti. What's his name? The other one. Somebody help me out. Jackson. Alan Jackson. Alan Jackson is standing there at the podium like waiting for her to finish reading. And then he starts talking, you know. Lally is there. He's sitting right there in the center of the prosecution's table, all slumped over. He should be slumped over because he should be ashamed of himself. Just saying. All right. Here we go. You can see Officer O'Keefe's family is sitting in their usual seats. Okay, there's Jackson. He's standing there waiting on Judge Bev to get it together. Okay. Hey, Margaret, good to see you. Good to see you.
Save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
Wasn't there.
All right, what they're talking about is the surveillance of the Sally Port. Okay?
Okay.
It was erased by an operation of automation.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address what our concerns are in my oral statement.
All right, I'll hear you.
May I?
Yes.
The court started by asking what is it that the defense is asking for. Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amherst scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now, defending herself against provably false allegations. And at the center of that storm of defense are these Sally Port videos. It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's a 24-hour period, 23 hours and 59 minutes. It should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been...
I'd like that. I mean, that would be helpful.
I'll be happy to do that. It's in discovery request after discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download, before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons, and I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, a prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. With failure to disclose evidence favorable to an accused that is material either to guilt or to punishment is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8 subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, and within their own time frame to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame, the missing portion is the exact time frame that the SUV was being pulled into the Sallyport. We got that video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame, that the Commonwealth tried to sell to the jury as a true and correct copy of a video within the Sallyport And we got that one after the trial started, in the middle of trial. So why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions. And literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another Sallyport video just a few days ago, this one showing the Lexus backing into the Sallyport from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source, had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out, you can have your expert come out, meet us at Canton, we'll provide the DVR, you can have him look at it, he can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote in his opposition that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault that we didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR? What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor, if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone. To punctuate the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that.
Yes, Kelly.
And that also proves that he lied in front of a federal jury, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence, and that's Brady evidence, and it was withheld in its entirety during the first trial and for the last 3 years. And it's against that, the reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert.
Hey, Mary Lou.
So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged. And
Listen,
all
keep
at Ms.
listening.
Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, the Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten within 30 days. What? How could that possibly be? So the expert calls me. Mr. Jackson, what do you want to do? And I said, I don't know. I'm not a tech. That's your job. I don't know what to do. If it's overwritten within 30 days, I don't know. Maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR, who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Collin Crawford, well, let's at least download the log. At least we can have access to that and we can start unraveling what's going on here. Oh, sorry, that's been overwritten as well. There is no log. You get no footage, you get no log. This was a complete and utter waste of time.
Wow. Wow.
According to the Commonwealth, that system, as I said, overwrites every 30 days. So by February 28th, I counted them, by February 28th, 2022, every single frame of that footage should be gone. So how did we get the inverted video in April of 2024?
Boom.
How did
If that footage auto erases after 30 days, then how did they get the inverted video? Remember the video that was like tried to trick everybody by it being inverted, like a mirror image or whatever? Remember that? Y'all remember that video, right? Where when you're looking at the video, it looks like you're looking at the tail light. How do I even explain that? Like you think you're looking at the one side tail light, but in actuality, it's on the opposite. The car is on the opposite. It's weird. It's an inverted image. Hey, friendly snake. Good to see you. It's been a while since we've had you over here. Hello, hello. Hola from Cabo. Cabo. That sounds amazing. That sounds amazing. Brenda, honey, I have no idea. I have no idea. But what he's saying, what Jackson is saying is, okay, if that DVR auto deletes every 30 days, and he counted back from the days that mattered, and if that's the case, then they shouldn't have had the inverted video. Right? So they're just picking and choosing what they want people to have access to.
How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone.
Right?
Admittedly. And all of that has been withheld from us for 3 years. Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd dollars.
$12,000
money and
$12,000, you guys, is what it cost her to have the expert, hire the expert, have them come out, lodging, travel expenses, all that stuff. Am I muted? Am I muted? Can you hear me? Let me know if you can hear me. Okay, Spins can hear. Okay. Okay, friendly snake. I was like, wait a minute. I'm a little bit gun shy because literally this happened to me the other day. I was like, oh no. I went on and on and on and on for like 5 minutes and then realized I was muted. Okay, good to know. Hey, Michelle. Hi, lovely. Hi, lovely. How are you today? Hey, Andrea. Hi, nice to see you. Hello and welcome. Okay, so, okay, good deal. Good deal. All right. Train of thought. My brain just went. What was I saying? What was I saying, you guys? Oh, the money, the $12,000. All that money for them to get the expert there. Then when the expert gets there, they go to get the footage and they're like, oh, we're sorry. It's gone. And that's the footage that their expert was going to expert, you know? So, here we go.
Fly an expert out to Canton for absolutely no reason. Zero. The 30-day override protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton. She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it, we knew it, Mr. Brennan knew it, everybody knew it. But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt. It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not.
I love how he called it a snipe hunt. I love that. Because that's pretty much what it was, right? Michelle, honey, you work and lurk. You work and lurk, ma'am.
Of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork and his declaration, and he spoke with some officer.
Listen to this.
And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire.
I love
and
him.
Ms. Reed has to pay for the fire extinguisher. And that's not fair. The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case, is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth.
Everybody get
and
your
for the
Lysol.
defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill.
Oh, yeah. By the way, you guys, look at this. Margaret says, oh, I forgot to tell the chat. She got a job, you guys. She got a J-O-B. Finally got hired after all this time. How long has it been now, Margaret? What did you say the other day? How long has it been? I'm so happy for her. I'm happy for you, Margaret. 7 months. 7 months. Yep. Michelle, she's all so excited for you. Mm, I'm glad, Margaret. I'm glad. You deserve it. And they're very lucky to have you, ma'am. They are very lucky to have you. Right. The time is right. Yes, it is. I'm so happy. You know what? I have to say, oh, hold on. I hear a husband. Hold on. I hear a husband. Oh. Can you guys hear them? Sparkles for that, please, right? I know, Michelle, right? There was something I was going to say, though. What I was going to say is that I remember back in the day when Margaret would type in the chat some wonky thing, like when we would be watching, like, I don't know. I don't remember if she was working or not during the Daybell trial, but I'll just use Chad Daybell as an example. Chad Daybell's lawyer would say something really stupid, and Margaret would type in the chat, "My coworker wants to know why I just fell out of my chair. My boss wants to know why I'm screaming at the top of my lungs." I miss those days, so it'll be cool when you get back to work. It'll be so cool. And yes, sparkler. Let's get some sparkles. Yes, ma'am. And here you go, because I know Margaret loves it. Ah. Funny, funny, funny. I'm super excited for you, though. She says, when I get settled in, I'll be typing all that again. They're a very laid back organization and will not mind a bit. Good. I'm glad. I'm glad. Me too, Michelle. Me too. Me too. Margaret's a hard worker and she's a go-getter. Absolutely. But like I said, they are lucky to have you. Okay? You don't forget that either, ma'am. Don't you forget that. Okay, let's get back to this. Yeah.
And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit.
Yeah, there he's looking. He wants her money back. He's like, she needs to be reimbursed. She wants her money back. That's what he wants, and I don't blame him. 'Cause they knew. They knew. Stay out from under the work fridge. Oh my God. Stay out from under that work fridge, Margaret. Yeah, we don't want this happening. Mm-mm. We don't want that happening right there. No. No. Stay out from under that fridge, baby. Oh, back to this comment from Margaret. She said, "Thanks, Michelle. Thanks all. It took me 3 tries to get into this place, and Shazam. Shazam." Third time's a charm. Isn't that what they say? Third time's a charm. Kel's giggling. She's like, no work fridges for me. I wanted to say come back 1 year. No work fridge for you. Come back 1 year. I don't think they have any. All the buildings have their own cafes, so I don't have to go near a fridge. Ooh, yay. But hey, now you need to let them know that you are exclusive to the crime cafe. Okay? Okay. I ain't gonna be having no other cafe bringing their nose up in my business. You belong to me. Sorry. I'm totally kidding. You know that, right? Okay, Kelly says, I'm now a lurker baking a cake for a chocolate and rom-com party, but still here. Ooh, can I go to that party? I want to go to that party. Can I get an invitation to that party? I want to go to that party. That sounds amazing. It's there because you're here, Margaret. That's why it's there. Yeah, Spins. Yeah. Spin says make sure you take your Tommy Tippy to work. Yeah, you don't want important papers to get, spilled on. That would end up going viral on the internet. Oh my God. Yes, congratulations. Assigned a loyalty oath to the Crime Cafe. Thank you, thank you, thank you. Not just any, right, Brenda? Oh, Margaret said, I'll be with you all tomorrow 1 year. So can I have a poll now? I started 2/7/24 with the Adam Montgomery trial. Really? I thought it was before that. Are you sure, ma'am? Maybe. One whole year, though. Wow. Yes, I have a clip of you saying, oh, we have a new subscriber. Hello, Margaret. Oh, cool. Cute. Right, Michelle, that was rough. We were all so angry because he didn't show his face the entire trial till sentencing day or whatever. Ugh. Oh, that's right. That's right, Margaret. You lurked before that. She's like, let me check these folks out and make sure they're not cray before I say something in the chat. Happy Crime Cafe anniversary. Yeah, that's cool. The worst one ever for me. That was a tough one for sure. That was a tough one. The Gannon Stalk one was a hard one for me. That was tough. That one was tough. I mean, Letitia is pure evil. Well, so is Adam Montgomery, but I'm just saying, they're like two peas in a pod. Oh my God. Disgusting. I mean, disgusting, foul humans. And I'll tell you another one is that Taylor Shabusiness. Oh my God. That woman is Looney Tunes. Kelly says, I still haven't watched the Gannon trial. That one was hard. That one was tough. Definitely, definitely. All right, let's get back to this. Let's get back to this.
Your Honor.
All right, thank you very much. Mr. Brennan?
Now, listen to what this man has to say. Okay? Listen to him.
It's notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required. Yet, I'm standing here today, and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you, and I must tell you what happened. When I entered this case in September, and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import. It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something, that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency and an effort to help the defense so there will be a fair trial and they
You know, I mean, that's probably how it should be handled, but I think that Jackson knows, allegedly, you might be hiding stuff. And he's tired of piecemealing this together because, like he said, he gets little bits and bobbles here and there every little bit. So, you're like, you know what? Let me just take somebody that knows what they're doing down there to the station and get what I should have. Because he feels, in my opinion, that they're too inept, is that the right word, to do it themselves and send them what they should have. In my 30 years, I ain't never seen anybody come and do. Well, now you have. Now you've met Alan Jackson.
can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial. I wanted to do what I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. So
Guess
I called
what? They
Attorney
couldn't do
Jackson
that.
back, and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence. And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR. And respecting his position, providing a professional courtesy, I agreed. Didn't mislead.
Okay, and secondly, I can't say that I blame him for him wanting his own expert to do it, because during the trial, your people flop out a video that is completely inverted and had nobody said anything. That was nuts. That was nuts. Not to mention y'all throw evidence in red Solo cups and ShopRite plastic shopping bags.
Lead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did, not surprisingly, the information had been overwritten.
That's real big of you.
Now, while there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, NVR, back in July of 2024, and I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear, I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras, I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them because they had already been part of the process. I thought it would be disingenuous not to let them participate. And what they told me
Right,
was to wait.
Morgana.
So now that information, whatever it is, I don't know because I haven't seen
You're
it.
so
And
sweet.
I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information to give a copy to the defense. The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite, Commonwealth versus Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup. This is the government providing information as the case progresses and evolves and changes and retools. So what we have now is information, supposedly, on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional courtesy in an effort to help, and they've distorted it into some type of injustice. The Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not be distracted from the cause in this case. If they have a separate motion about Rule 14 violations or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
Okay. Any quick response, Mr. Jackson?
Very briefly, with the court's permission.
Sure.
By the way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case, don't worry about it, let's just sweep this under the carpet like we've done everything else. It's there's nothing to see here. That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins' part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well. The inverted video part is also Brady, which we got in the middle of trial.
In the middle of trial.
Mr. Brennan says, basically, his argument is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all. This is about the defense and the Commonwealth. It's about Ms. Reed and the Commonwealth. But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him. I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over. I can't fault him for that. He turned it over when he found it, apparently. What I can fault is the Commonwealth. Mr. Brennan was brought onto this case not to represent Mr. Brennan, but to represent the Commonwealth. And all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility as lead counsel for the Commonwealth. He indicates that when he found out that we wanted to come look at the...
He's sitting. If you didn't already notice, this prosecutor dude is sitting right next to Lally.
DVR, and we had absolutely no right to look at that DVR. This was just a courtesy, etc. Well, that might be true if we hadn't made the request, because we had been getting piecemeal videos from a DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right. So my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine. You want to keep your hands clean, let's do it the transparent way. Have everybody come, bring their experts, whoever they might be, and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it.
No funny business like inverted videos. Keep going back to that.
Except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart. Until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR. You can come look all you want to. The bucket's empty. I have no idea about this iCloud account, or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that, because this is literally, these are the contours of the motion that's going to be before the court. And I still want to defer it, because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that it won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't mean to interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that, because I still want to have some transparency on that process. But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something dollars for absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. And by the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case. And the ultimate opinion of that court was, when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court, blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one told it. I wasn't the one that downloaded it. Buchanan. I wasn't the one that downloaded it. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody for those videos, and we still don't have it. So Chief Rafferty's statement, yeah, come on out. No hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround, and it was ultimately
they make a good team.
Cost, and that's what's
so didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes, I was concerned, but who cares? Well, that's no legal moment. What I thought and what Mr. Brennan and I discussed 3 years after the fact, when the Commonwealth has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but demand to maintain that information.
So where is that demand? Is that in the file? Where is that demand?
February 2nd, I don't know what the docket number is. It was filed on February 2nd after arraignment.
Here?
Wherever the arraignment was, Mr. Yannetti.
It was in the Stoughton District Court.
Okay.
But it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, when was that filed, and did Mr. Brennan
No,
actually...
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court.
I may...
I don't know where that's at that they're talking about. The request for them to preserve that. But I do know that little Miss Sleuthy over there on Twitter found it. She found the actual document that Yannetti wrote up. She's like, I found it in 2 seconds, Bev. And I was like, go, Sleuthy. It's your birthday. It was cute. She's on top of things, man.
may have filed it as an
As an
exhibit.
attachment, but it was
but
never
not-
any,
Right. There was, and I don't mean to cut off the
no,
court,
no.
Judge.
It was never brought before me or a judge who had this case before me to be heard.
So there was, early on, and so many motions have been filed in this
Right.
case, but early on, I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court.
Okay.
That is in our record.
So I need you to find that
Happy to do it.
and tell us when it was filed, the act, I need to see
By
that.
the end of the day today, you will have whatever submissions we provided, and if it's not part of an exhibit, you will have that motion.
Yeah, Bev. Move them
Go ahead.
bangs
So-
out of your
so
eyes,
that's
then you
one
might
of
be
the
able to
questions I
find
can't answer
stuff.
because I've seen the filing. It was filed February 2nd, 2022, court stamped. My point is, even if that weren't the case, and it is the case, the obligation is self-executing. That's what Justice Graziano was talking about when he talks about in the committee case, the self-executing duty that a prosecution has.
Put little
or a
Bev up there in the
prosecutor
corner
has
and let her sit there
to
for a while.
maintain and preserve exculpatory information and provide that information to the defense. They didn't do that, and they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that that information existed, the DVR existed, the video footage on the DVR existed, and we were going out there to know. We shouldn't have had to go.
Let her
through
think about
jumping
her
through
choices,
and
right?
go on this wild goose chase at Ms. Reed's expense. It is not, I think we can all in this courtroom agree, none of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason. And I'll submit.
All right, Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR NVR. That's the actual system that keeps all the footage that's recorded. That has been
That
served.
commonly is overridden every
Yes.
30 days,
That
like
has been overwritten.
statewide police departments.
Yes, Your Honor. And
Okay.
that has been overwritten.
Okay.
And there is no information on that.
Michelle.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would
Michelle, honey, this case is so convoluted. I mean, there are so many key players in this. She says, I'm so lost. All I know is there's a bitty judge, a lot of drinking with cops, and one ended up unalived either by Karen Reed, cops, or a dog. And it was snowing. Yes. Little Judge Bev is keeping an eye on all of us to make sure we are all being good, even though she's not doing a good job in court. Right. Michelle, yeah. She said, Morgana said, you got it, Michelle. Kel said, I think Michelle nailed it. Pretty much. Yeah, pretty much. Pretty much.
routinely, when he would make a video copy from the DVR, he would place it in a separate file.
That's our Judge Bev
Can't
up there
say
in the
that it's
corner of the
exhaustive.
screen
I
here.
can't say that it captures all of the video. It's when he would make a copy, and it seems in this case there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it and the obligation of the Commonwealth, I think, is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court and the Commonwealth, or the Commonwealth and the defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
All right, so I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd make a download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right, I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first
Yeah,
place.
so let's try and work it out before you leave here today, okay?
Sure.
Your Honor, I'm happy to defer the defendant's request. I'm prepared to do it now. If they want me to wait, if they want to have somebody there, I'm receptive. But we're ready to do it now.
All right, so I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you. Did you want to be heard further? in
Briefly,
response?
Your Honor, although I've come into this case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion for sanctions or to dismiss, or whatever the remedy is, because they think they've been agreed, that would be a different motion. This motion is they're trying to get the court, or asking the court to impose costs because they had their expert come out at their request, and they were very clear about the risks associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had known that the defense was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Yannetti's motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of this motion. This motion should be denied.
All right, thank you very much. Taking this under advisement. And do not wait for a decision from me on this about whether or not you send somebody out.
And do not tear up the microphone, dude. She's like, and do not wait on me to whatever, blah, blah, blah. And he's literally tearing the whole computer, or the whole laptop thing down. Or not laptop. What is on the guy's laptop? I don't know. What is that? I have no idea. I can't tell. And is that Turtle Boy sitting there with that whatever on the laptop? I can't. Can anybody tell if that's Turtle Boy? Kind of looks like the back of his head, maybe. I can't tell. Anyway,
To get that video.
We'll get started on that immediately.
All right. All right. So let's.
kind of looks like him, and I wonder if it's not his arch nemesis that he's looking at on the computer. I can't remember that guy's name. Anyway.
Move on to the Commonwealth's motion for clarification regarding the search warrant. Or the contents of the defendant's phone, more accurately. Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Miss Reed's phone. That search warrant entitled the Commonwealth to search for data that's outlined in what's known as addendum or attached as addendum A. Learning the history of this case, I further learned that because there was an assertion of privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privilege information, extract it, and then provide the information back to the government and the defense. I am not sure of the accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked through the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report. And when we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly, the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information than simply a PDF. And so when I learned this, I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request for the data to navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution and respect to the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information. I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so that the court could give direction, either assuring the Attorney General's office that they could provide the information, or if there is going to be a protocol, which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very, very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. If they have a remedy, it's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st file, and we will pursue this information and use it if relevant.
Okay. Is there an opposition? I don't have anything in writing.
Your Honor, not really. The only thing that we expressed to Mr. Brennan was, and maybe I misunderstood his first, there was a communication that we had on the phone. I thought that he was seeking something far broader than the search warrant. It sounds like he's staying within the parameters.
It sounds squarely within the search warrant.
So that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court just said, squarely within those parameters. January 28th at 9:30 p.m. until January 29th at 5:30 p.m. And otherwise, I don't disagree that pursuant to the search warrant, he can get the. I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right, it's squarely within the search warrant.
Right.
I do feel Mr. Brennan did not have to come to me or even you with it, but I do appreciate that you did so. So yes, so the AG's office knows that you are entitled to that information. You may have it immediately.
Thank you.
Okay. All right. So the motion regarding, just want to get, Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar and tell me any information you have? Or how do you want to do this?
Whatever the court's most comfortable with.
I'd
An open court or sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
Yes, Your Honor.
Okay, the whole sidebar situation. Like I said, they're there forever. They're in this sidebar for like 52 days. It's forever. Not literally, right? But feels like it. Let's see. 48. Somebody count. From 48 minutes to... we'll say 1 hour and 2 minutes. So really, it was a 12-minute sidebar? Feels like longer than that, but maybe it's because I was watching in real time at the time.
All right, so I will hear you, Mr. Brennan, on your motion for reciprocal discovery.
That is Turtle Boy, because his last name is Kearney.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCA experts. Those requests are consistent with information that we routinely provide pursuant to Rule 14, and we are asking that the defense comply if they expect to call these witnesses at trial.
And you've asked for, you have specific requests for the discovery, right?
I do.
All right. Mr. Jackson?
Thank you, Your Honor. I appreciate the opportunity to be heard on that. I appreciate Mr. Brennan's indication that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
Okay. All right, so the motion is allowed. And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from. I believe that upon review and analysis, some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now. I don't think that's a reasonable possibility. We simply cannot get it done.
5, actually, Jackson,
I
5.
would ask the court and urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think it's going to be that burdensome, although it's going to be a very, very full-throated motion.
All right, so you first raised the issue, I believe, in a footnote on one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss it, the last trial, the same thing, forecasted, and then it's coming, it's coming. I need that motion in order to get it heard before then. Let me hear what the Commonwealth has to say. What's the extent of the information that you provided today or yesterday?
In the most recent discovery,
Yes.
it was voluminous.
Okay.
We provided a number of expert witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone investigations. So we sent it by link because it was extraordinarily large.
Okay. Does the defense anticipate evidentiary motions in this case? Got time that maybe I can flip these. Do you anticipate evidentiary motions?
Can I just? I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
How about the Commonwealth?
They are not expected.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss. And we'll hear it if there are no evidentiary. Commonwealth, I'd like you to comply with your response if you could by the 27th, 28th. Oh, wait, this is March, I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th. And I want you to talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible, I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us the 24th to file a motion to dismiss? That gives us a weekend. That is incredibly meaningful for us. I don't want to hamstring the Commonwealth if they need until the 3rd to give them a weekend.
You know,
Possible?
but also, I need weekends.
Right.
So it's not possible. So I'm giving you from February 11th to February 20th. I'll give you to the 21st.
Okay, 21st. Thank you, Your Honor.
Commonwealth, I'll give you to the 28th. Okay?
Thank you.
All right.
So Judge, are we taking off 218?
We're going to take let's keep it on now.
Okay.
If you work out if you believe that it would be helpful after talking to do a voir dire of those witnesses, we've got the 18th free.
The 18th of
February. You were supposed to be here anyway on your motion to dismiss.
Okay, I'll discuss it with Mr. Brennan.
All right. Thank you all.
Your Honor, may I?
Yes, I'm sorry.
A few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been
Yes.
a date sent. I'd like to.
All right, so you were filing your notice of compliance today. Do you have it now to file?
I do. Can I just show
Okay.
it to the defense?
Sure.
Oh, it's extra copy? Okay. This one, if you like. Awesome. Thank you. May I hand this in, Your Honor?
Thank you.
Thank you, sir.
All right. So all reciprocal discovery be provided by March 6th. All right, thank you all.
One last.
Yes, I'm sorry.
Could we come sidebar for this?
Sure.
Another sidebar. Another sidebar.
Mr. Jackson, anything?
No, Your
That beep sounds like a hospital.
Mr. Brennan, anything else?
Thank you very much, Your Honor.
Mr. Jackson, anything?
No, Your Honor, thank you.
All right, thank you all.
All right, please.
Hold on a second,
You
guys.
are
I'm
muted.
looking for something real quick.
Thank you.
Here, just take this. Battery's probably pretty close to dying. I'm gonna power it off now. That's one of those 3-seconders. Just hold it down for 3 seconds. Yep, and then hit that thing for record. All right, and you probably got. Yeah, well, I was gonna say you got about 5 minutes before she heads out. So if you want to leave your phone back here.
Goodbye.
Hand it to me. I'll just go back there and put it there.
Okay, sorry. I was looking up that Robbie Robinson, the dude that said his mother-in-law, or, well, no, it would have been his but they weren't married yet. The one we were talking about, the other day, about the man that set his dad's fiance on fire, remember? Bev seems medicated. Oh, no. She does kind of seem chill, right? Hold on. Shoot, I closed that one tab. Let me reopen. Hold on a minute. Just a minute. Hold on a minute. This was the website that I found. No. Where did it go? Okay. Okay, I found it. Now let me see. Let me open. I'm sorry, guys. I'm all over the place right now. Hold on a minute. Hold on a minute. Okay, that was day 1. Okay, so I found it. I found the trial. For some reason, it's not being streamed on Law and Crime or Court TV, but I did find the trial. They started opening statements yesterday, and the jurors took a view of the house where the woman jumped out the second-story window, and today was day 2. So, because it's a late start, what say tomorrow we start this one? What do you think? Oh, Miss King says I watched some of that yesterday. Where did you see it at? I'm only finding it on some local news channel to the area, I guess. What was it? WCPO, ABC. Yeah, we might be able to get caught up by over, before the weekend on these 2 days, depending on how many. Because I was reading, somebody said something about a sidebar every 3 minutes. That's not encouraging, but I'm interested in that one. And then this weekend, I also want to get caught up on the Megan Boswell. So anyway, that's what I guess we'll do tomorrow. Well, wait a minute. I have a doctor's appointment tomorrow. My doctor's appointment is at about 3 o'clock. So I might try to start early tomorrow. Hey, Patricia. I was going to actually ask your mom where you work because I'm like, I'm missing Patricia today. I see you, girlfriend. She said, I have to rewatch. I just got here. Hey, hey. Bev sure stays the same. I know, right? I know. Michelle, the one I'm talking about, his name is Robbie Robinson. And here, hold on, let me ba-da-da-dum, ba-dum. Hold on just a second. His name is Robbie Robinson, and he's in Ohio. And I don't know how old he is. I'd say mid to late 20s, maybe early 30s, but I doubt it. Anyway, he's on trial for what happened was, allegedly, he set his dad's fiance on fire, and she jumped out a second-story window of their house. The neighbor called 911. When they got there, the Robbie Robinson dude was running away. They apprehended him, and the woman was still alive when paramedics and police got there, and she said he did it, and he knocked her 2 front teeth out, or knocked 2 teeth out anyway. But then after she got to the hospital, I don't know how long she lived, but she ended up dying from her injuries. And so he's on trial for capital murder. Yeah, he's on trial for capital murder. So he's facing the death penalty, man. Yeah. Yeah. Now, I don't know. Law and Crime or Court TV might end up picking it up once they, But then again, maybe they won't. I don't know. But we can do that tomorrow. And we can start early. Trying to think. Kiddo's morning sesh is done at hold on, let me think. Yeah, there we go, Miss King. That's what it was. That's where I found it, was WCPO 9. Hold on. Trying to think. She finishes by about 9:45 or 10 in the morning when they're on normal time. So I'll plan on starting it then. Right around that time. Crazy case, right? When did that happen? I don't remember I don't know how recent this was. The arson and felonious assault for the May 11th, 2023 incident. So, almost 2 years ago. Wow. Crazy, right? Whoa. Back up, Jack. StreamYard's doing the most right now. They're like, here, let's put her whole face over the entire screen. No, thank you. I don't like that. So we'll do that. We'll do that tomorrow. And I'll plan on starting it somewhere between 9:30, 10. Give or take. Okay? And then I'll have to end it. Because I'll have to go to the doctor I have to be there at like 10 after 3. So I'll have to leave here like about 3 or a few minutes before. And the first day it says is like 5 hours and 20 some minutes. But a lot of that is a jury view. So we'll be able to skip a nice little chunk of it. And then start getting into the testimony. Nice. And then day 2 is 6 hours and 31 minutes. So we might have to stream that on Saturday. I might have to stream this weekend. I mean, I'm up for it. Yes, Michelle. We actually talked about that at the beginning of the stream today. That was the first thing we talked about. Well, first thing I talked about was my blood pressure and blood pressure medicine. But then after I got through that whole rigmarole, we talked about Collin Griffith. Yes, we did. We did. Blew my mind. Blew my mind. Margaret says, good, I'll be able to catch before my first day. Yay! I'm so excited. I know, right, Cherie? Mm-hmm. They want me there at 9 my time tomorrow. So that's noon for me. I was so sure he would be. I was saying earlier in the stream today, a while ago, I was really expecting either guilty or a hung jury. And the only reason I was thinking the hung jury is because I'm thinking, there are probably some jurors. I could totally see some jurors being like, this dude cried for help and nobody listened to him. Serial in the making now. What do they say? 3? Is it 3 or more? That's a serial killer. I don't know. I pray to God not. I don't know. I mean, I didn't watch it enough. I didn't watch enough of the trial to know. I do, and this is something else we talked about earlier, I do find it strange that there are 2 instances of having to kill someone because of self-defense twice before you're even by the time you're 17 years old. I just feel like that's weird. I mean, that's like, talk about random, right? True self-defense. If it's truly self-defense, once in a lifetime is pretty much it. 2 by the time you're 17? I don't know. That's what a lot of people are saying. A lot of people are saying that. I hope not. I hope not. I hope for his sake it really was what he says it was. And I don't know, man. I don't know. But yeah, we'll do the Robbie Robinson tomorrow. I'm kind of excited for it. As excited as you can be about a murder trial, right? Anyway. All right. I love you guys. Thank you for hanging out with me today for a little while. I appreciate it. Oh, does anybody know, while I'm thinking about it, does anybody have any tips or tricks on how to get my watch? Because I never could figure this out before. And I tried to figure it out again last night or the night before, and I'm still not able to figure out what I'm doing wrong. But I'm trying to use my watch to monitor my sleep stages at night, and I have my Apple Watch connected to my phone's health app, and I have the sleep focus on. I have the sleep schedule figured out, all that stuff. But whenever I go to look at my health app in the mornings, instead of getting the pretty different colored, like rim, hold on, I'll show you. Like when you click on more data or whatever, you see the different stages. There's average awake, average REM, average core, average deep stages, right? And then when you click on the day, it's the same thing, right? But hold on, I'll show you what I get. Hold on. Let me take a screenshot of it real quick so I can zoom it so you guys can see better what I'm trying to show you. I don't know what I'm doing wrong. Okay. Instead of getting the multi-graph, color graph showing me all those different stages, this is all I'm getting is just a green bar that's telling me time in bed and time asleep. And where the things are here at the bottom, hold on a minute, where it shows the different stages, there's just dashes. There's no numbers there. I don't know what I'm doing wrong. I don't know. But I'm super frustrated. Because when I was at the doctor, she said that one reason why She said one reason why you premium? No. There isn't a premium on the health app, I don't think. It's just the Apple Health. I don't see a premium option. Don't get frustrated. I'll show you an app. Okay. Okay. Set it in the phone and where the I did, Michelle. I did all of that. I went and searched. I went and looked on like Apple forums and Reddit, all of them, and I've done everything they've said. I've even like deleted my sleep schedule and recreated a new one, synced it, all that stuff. I don't know. But when I was at the doctor the other day, she said one reason why people, she said especially at your age, because she said I'm too young to be having this kind of issue. I was like, thank you so much. Anyway, she said that one reason why people still have high blood pressure despite taking blood pressure medicine, one of the top one reasons is sleep apnea, which I have, and I wear a mask. But she said sometimes that's, can be a problem. So she said you have to make sure you're getting enough REM sleep every night. And she's like, you can use your app. And I'm like, yeah, I tried that before. I'll have to try it again. And I can't figure it out. So anyway, I'll have to holler at you, Margaret. You'll have to tell me where to go. Okay. But I'm going to get out of here. Before I do, one more thing while I still have all of you guys here. And I wanted to, she doesn't know I'm asking you for this, but I would love and appreciate it if you guys would send up some prayers, thoughts and hearts into the chat for our QB. And I'm just going to go ahead and take what do you want to call it? I'm going to go ahead and make the executive decision to let you know that she has not given me permission to say this. And QB, you can be mad at me if you want to. But M passed away. So that's where she's been. She's been taking care of M all this time. She's been going downhill, and QB, don't ask for much from people. And I know that you all love her, and I know that she has shared M with us, and we're blessed to have known M through QB. And so hey, Gail, good to see you, ma'am. Good to see you. But yeah, so she's like I said, she did not give me permission to say that. And I hope she'll forgive me if I've overstepped. But I just really want you guys to know that she, is on the struggle bus. So, and I know that you guys love her. So, Gail said I've been lurking. I had to come out for our QB. I know, right? And I love that you lurk and don't say anything, Gail. I love that. I love that. She'll feel the love. She'll understand and feel the love and prayers. I know she will. I know she will. But yeah. I don't know what her kiddo just ran down the hallway after her daddy. I don't know what for. But yeah. And I know that QB will be back with us soon. She just, needs some time to come down. Being a caretaker is hard business. That's hard work. Physically and emotionally and mentally. It's hard. So. All right. I'm out of here. I'm going to go. I haven't said hi to my husband since he's been home from work. I'm going to go say hey to him and get some other things done. But I'll be back tomorrow morning. Okay? We'll start the stream tomorrow morning for the Robbie Robinson trial tomorrow. All right. I love you guys. Make sure to hit the thumbs up before you leave. Subscribe if you're new. We'd love to have you join our Crime Cafe crew. And hashtag replay in the comments down below if you're watching this on the replay. And QB, if you happen to catch this, I hope you feel all the love in the chat. And I love you too, friend. Okay? Bye, guys.